Be ready. Start. A fortiori, besides legal logic, mandatory auction may be contrary to economic logic as well. Different resources may require different treatment. Very often, exploration and exploitation contracts are bundled together due to the requirement of heavy capital in the discovery of natural resources. A concern would risk undertaking such exploration and incur heavy costs only if it was assured utilization of the resource discovered. A prudent business venture would not like to incur the high costs involved in exploration activities and then compete for that resource in an open auction. The logic is similar to that applied in patents. Firms are given incentives to invest in research and development with the promise of exclusive access to the market for the sale of that invention. Such an approach is economically and legally sound and sometimes necessary to spur research and development. Similarly, bundling exploration and exploitation contracts may be necessary to spur growth in a specific industry. The court must always remember that legislation is directed to practical problems, that the economic mechanism is highly sensitive and complex, that many problems are singular and contingent, that laws are not abstract propositions and do not relate to abstract units and are not to be measured by abstract symmetry, that exact wisdom and nice adaptation of remedy are not always possible, and that judgment is largely a prophecy based on meager and uninterrupted experience. Every legislation, particularly in economic matters, is essentially empiric and it is based on experimentation or what one may call trial and error method, and therefore it cannot provide for all possible situations or anticipate all possible abuses. There may be crudities and iniquities in complicated experimental economic legislation, but on that account alone, it cannot be struck down as invalid. The courts cannot, as pointed out by the United States Supreme Court in Secretary of Agriculture versus Central Rag Refining Company, be converted into tribunals for relief from such crudities and iniquities. There may even be possibilities of abuse, but that too cannot of itself be a ground for invalidating the legislation, because it is not possible for any legislature to anticipate, as if by some divine prescience, distortions and abuses of its legislation which may be made by those subject to its provisions, and to provide against such distortions and abuses. Indeed, howsoever great may be the care bestowed on its framing, it is difficult to conceive of a legislation which is not capable of being abused by perverted human ingenuity. The court must therefore adjudge the constitutionality of such legislation by the generality of its provisions and not by its crudities or iniquities or by the possibilities of abuse of any of its provisions. If any crudities, inequities, or possibilities of abuse come to light, the legislature can always step in and enact suitable amendatory legislation. That is the essence of pragmatic approach which must guide and inspire the legislature in dealing with complex economic issues. Where a statute confers discretionary powers upon the executive or an administrative authority, the validity or constitutionality of such power cannot be judged on the assumption that the executive or such authority will act in an arbitrary manner in the exercise of the discretion conferred upon it. If the executive or the administrative authority acts in an arbitrary manner, its action would be bad in law and liable to be struck down by the courts, but the possibility of abuse of power or arbitrary exercise of power cannot invalidate the statute conferring the power or the power which has been conferred by it. Therefore, a potential for abuse cannot be the basis for striking down a method as ultraviolates the Constitution. It is the actual abuse itself that must be brought before the court for being tested on the anvil of constitutional provisions. In fact, it may be said that even auction has a potential of abuse, like any other method of allocation, but that cannot be the basis of declaring it as an unconstitutional methodology either. These drawbacks include cartelization, winner's curse, the phenomena by which a bidder bids a higher, unrealistic, and unexecutable price just to surpass the competition, or where a bidder, in case of multiple auctions, bids for all the resources and ends up winning licenses for exploitation of more resources than he can pragmatically execute, etc. However, all the same, auction cannot be called ultravires for the said reasons and continues to be an attractive and preferred means of disposal of natural resources, especially when revenue maximization is a priority. Therefore, neither auction nor any other method of disposal can be held ultravires the Constitution merely because of a potential abuse. The learned Attorney General also argued that dictating a method of distribution for natural resources violates the age old established principle of non interference by the judiciary in policy matters. Even though the contours of the power of judicial review of policy decisions has become a trite subject as the courts have repeatedly delivered opinions on it, we wish to reiterate some of the principles in brief, especially with regard to economic policy choices and pricing. Thank you.